To amend the amending power itself. No restraint having been imposed on the power to end the amending power, it is unnecessary to seek better evidence of the width of the power of amendment under our Constitution. The power of amendment, a safety valve, and having regard to its true nature and purpose, it must be construed as being equal to the need for amendment. The rule of T construction is out of place in a constitutional act, and a construction most beneficial to the widest possible amplitude of its powers must be adopted. p. 964 to 967. The Constitution is the fundamental or basic law, and it is a law of superior obligation to which the ordinary law must conform, unless constitutional law was expressly included in Article 13. It would fall outside the purview of Article 13.2. The fundamental D1 STMC well known between constitutional law and ordinary law lies in the criterion of validity. In the case of constitutional law, its validity is inherent. In the case of an ordinary law, the validity has to be decided on the touchstone of the Constitution. The majority view in Goloy Nath did not on the construction of Art 13.2 accord due importance to this essential distinction between legislative power and the constituent power. The distinction between flexible and rigid constitutions brings into sharp focus the true distinction between legislative and constituent power. This is the distinction which was not given due importance by the majority in the Goloy case. In a rigid constitution, the power to make law is the pus, of which the legislative and constituent powers are the speci, the Dilfker being the procedure for amendment. If the procedure is ordinary, the pausia legislative. If it is special, the pauker is constituent. Thus, in a rigid or controlled Hamar constitution like the Indian constitution, a law amending 11C constitution is made in the exercise of a constituent power and partakes fully of the character of constitutional law. Laws passed under the Constitution of which the validity is to be tested on the anvil of the Constitution are the only laws which fall within the terms of Article 13, Power 2. An amendment of the ISR Constitution within the terms of Article 368, not being law within the meaning. All Article 13, 2 cannot become void on the ground that it take away or arid the rights conferred by Pan the 3 pp. 970 to 1973. Mika Fali VTA King, 1920. AC 691. Referred to 76. SDP IULML Kami. R. Iul Porn, 1973. Sapel. Forsi 1 Tias de Bekuk to accept the argument that inherent limitations should be read into the amending power of the. There is intrinsic evidence in Part 3 JF the Constitution to show that the theory of natural rights was not recognized by the framers of the Constitution. Citizens and non-citizens possess and are entitled to exercise certain rights of high significance for the sole occasion that they are conferred upon them by the Constitution. The natural rights theory stands by and large repudiated today. The notion that societies and governments find their sanction on a supposé contract between independent individuals, and that such a contract is the sole source of political obligation, is now regarded as untenable. The preamble is a part and a provision of the Constitution. Therefore, the contention that the Constitution cannot be amended as to destroy the preamble is untenable. P.I.S. 976 Venkataramana Devaru and Orsva. The State of Mistwe Antlors 1920 SCR. 895, 990 View contra Inberu Bilri case. 1960 J3 SCR 250. Diunu de la Fondi Absen of an CXPR. As prohibition is highly relevant for inferring that there is no implied tohihitia. O is not open ear. O the counts to DC late an act void OI. Title 368 admits of no doubt or ambiguity J is that such a language leaves no scope for implications unless in the text of the entire instrument in which it occurs such implications bicro MC corapulsi. The context docs not merely mean the position of a word to be kodolal UCDJP, the collocation of words in which it appears, but it also macam the coup-text of the times in which a fundamental instrument falls to be construed. An important rule of construction which has a direct bearing on the submise osmayan jot die petitioner on their inherent limitations is that if the text is explicit, it is conclusive alike in what it directs and what it forbids. The consequences of a particular construction, while the text be explicit, can MVC no impact On the construction OA constitutional. Provision, no provision incorporated in 3 Constitution. At T1JP time of its original 1 enactment can ever. He struck down as unconstitute all the same test rens apply to what?